Welcome to the Deep Dive. Today, we're plunging into a really pivotal Florida legal case. It offers some profound insights, I think, for anyone navigating the complex world of open government law. We're going to unpack Booksmart Enterprises, Inc., v. Barnes Noble College Bookstores, Inc. It's a fascinating ruling from Florida's 3rd District Court of Appeal back in 1998.
Yeah, it's a classic. Really shows how the boundaries of what counts as a public record and, who has to disclose them can be tested.
Yeah.
And maybe redefined in surprising ways.
Exactly. It's not just about textbooks, is it?
Not at all. It's really about a critical interpretation of Chapter 119 Florida statutes, the Public Records Act.
Right.
And our mission today really is to dig into the core nuggets of knowledge from this case. It reveals quite a bit about how even a private entity, one working under contract, can find itself, right in the middle of public disclosure laws.
We'll explore what counts as a public record as a custodian. Some surprising stuff there.
Definitely.
So let's set the scene. It's kind of a classic setup, actually. On one side, you've got Booksmart Enterprises. They run off-campus bookstores trying to compete.
The challenger, basically.
Right. And on the other, the incumbent. Barnes Noble College Bookstores. They had the contracts, the exclusive deals to operate the official on-campus stores for FIU and FAU, Florida International and Florida Atlantic universities.
Big state universities. And the core of the fight was over these seemingly simple documents, blank forms, actually, that Barnes Noble gave out to instructors.
Okay, what were these forms for?
Well, instructors used them to list the courses they were teaching and, critically, the required textbooks for those courses.
The key information.
Exactly. Once they were filled out, signed sometimes even by a department chair, they went back to Barnes Noble.
So B&N knew exactly what to stock in their on-campus stores.
Precisely. Ensuring students, had the required materials right there.
Okay, so Booksmart, being the off-campus competitor, obviously wanted that information too.
Makes sense. If they knew what books were required, they could stock them and compete head-to-head.
So they asked for copies of the completed forms, arguing they were public records.
They did. They argued Barnes Noble was the custodian of these public records and had to provide access.
And Barnes Noble's response?
A flat no. They refused. They basically had two main arguments.
Okay.
First, they said the completed forms were trade secrets, confidential business info.
Okay, trade secrets. What was the second?
Second, they pointed to their contracts with the universities. Those contracts specifically stated Barnes Noble was not an agent for the universities for any purpose.
We're just a contractor defense.
Pretty much. So they argued, we're not an agency, not an agent, so Chapter 119 doesn't apply to us.
And Booksmart didn't back down. They went to court.
Yep, took it to the circuit court to try and force disclosure. But initially, the circuit court actually sided with Barnes Noble.
Interesting. So the appeal was crucial. Let's unpack that. The first big hurdle for the appellate court.
Yeah.
Were these forms actually public records under Florida law?
Right. That was the threshold question. And it's where things get really interesting for open government folks.
How did they handle the trade secret argument first?
Well, the court dismissed that pretty quickly. Barnes Noble tried to frame them as exempt business compilations.
Under the statute, section 812.081.
Right. But the court looked at the completed forms themselves and said, nope, these aren't compilations of information in the way the law means.
So not like a curated customer list or something uniquely assembled.
Exactly. They were just individual records of university decisions. So even if they had met other exemption requirements, which the court doubted, they weren't the right type of document to be a compilation. That argument failed.
Okay, so trade secret is out. How did the court define them as public records then? What was the basis?
They went straight to the Public Records Act itself, section 119.0111, and that definition, as you know, is incredibly broad in Florida.
It really is. It covers all documents, papers, letters, basically any material.
Regardless of physical form, made or received, pursuant to law or ordinance, or in connection with the transaction of official business by any agency.
That last part is key, isn't it? In connection with the transaction of official business.
Absolutely. It's less about what it is physically and more about why it exists its function in relation to agency business.
And didn't they also bring in precedent, that Chevin case?
Oh, definitely. Chevin v. Byron, Harless. a foundational Florida Supreme Court case from 1980 on public records.
What did Shevin add to the mix?
Shevin clarified what public record means in practice.
Mm.
The Supreme Court said it's any material prepared in connection with official agency business, which is intended to perpetuate, communicate, or formalize knowledge of some type.
Okay, perpetuate, communicate, or formalize knowledge.
Right. And crucially, Shevin distinguishes these records from mere precursors, things like rough drafts, personal notes, stuff not meant as final word.
So internal brainstorming notes might not count, but a memo communicating a decision would.
Exactly. Inter-office memos communicating official business. Those are public records under Shevin. It's about whether the document finalizes or communicates knowledge related to agency functions.
So applying that Shevin test,
Hmm?
how did the textbook forms stack up? Were they just notes or something more?
The court found they were definitely more. They were public records. Why? Because they were completed on behalf of the universities by the instructors.
Even though the instructors worked for the university, not B&N directly.
Right. And it was in connection with university business, specifically the official selection of textbooks. That's a core academic function.
And it needed to be formalized, communicated.
Precisely. The court said the textbook decision had to be memorialized in some fashion, so courses could be taught consistently, and the forms communicated that decision, that knowledge, to the bookstore.
So they serve both a memorialization and a communication purpose related to official business.
Bang on. Met the Shevin test, met the statutory definition, therefore public records.
Okay, that's a huge finding. But what about Barnes Noble's other argument? The big one. We're not an agent. Our contract says so. How did the court handle that?
Yes. The agency question. This is probably the most critical takeaway for anyone dealing with public-private partnerships.
Because the contract language seemed pretty clear, right? Explicitly denying agency.
It did. But the court essentially said, that doesn't matter as much as you think.
Really?
Yeah. Because the documents were public records, and they were, quoting the court here, turned over to the keeping of Barnes Noble to serve the purposes of the universities.
As well as their own purposes, presumably.
Right. Because B&N held these public records to fulfill university function, B&N became the custodian of those public records.
And being the custodian.
Made them an agent of the universities for the purposes of the Public Records Act.
Wow. So the function dictated the status, overriding the contract.
Precisely. The court pointed straight to the definition of agency in Chapter 119 itself, Section 119.0112.
Which includes...
It explicitly includes private entities acting on behalf of any public agency.
Acting on behalf of. That's the key phrase.
That's the functional test. The court cited other cases, Wallace, Wisner, that also emphasized function over formal labels or contract language. If you're doing the public's work, holding the public's records, you're acting on behalf of the agency.
So the contractual disclaimer about agency was effectively irrelevant for public records law purposes.
That's what the court ruled. Because they held public records created for university business, they couldn't deny access to anyone, including their competitor, Booksmart.
So the appellate court overturned the circuit court, sent it back with instructions to grant Booksmart access.
Correct. Complete reversal.
It really hammers home that point. Substance over form. If a private company performs a public function involving public records, a contract saying we're not an agent isn't a magic shield.
Absolutely not. It's a crucial warning for any private entity contracting with government. You have to understand how your function might bring you under the umbrella of public records laws, regardless of contractual attempts to avoid it.
It has huge implications thinking about all the privatized services now.
Yeah.
Utilities, park management, data processing.
All potentially covered if they are acting on behalf of the agency and handling records related to that official function. Transparency follows the function, not just the government payroll.
Now, there was also a concurring opinion, wasn't there? From Judge Johnson. He agreed with the result, but raised a different kind of point.
Yes, and it's a really thought-provoking one. Senior Judge Johnson agreed the law, as written, led to this result, but he expressed, well, some reservations about the policy implications.
What was his concern?
He basically said, I don't think the Florida legislature ever intended for one competitor to reap the benefit of the effort, money, and energy of its rival, where state agencies have privatized their operation.
Ah, the fairness issue. Letting Booksmart benefit from Barnes Noble's work in gathering this information.
Exactly. He acknowledged the court had to apply the law as it stood because there was no specific exemption covering this scenario, no exemption meeting the constitutional requirements in Florida for shielding public records.
But he felt it created an unintended consequence.
Yes. He essentially put the ball back in the legislature's court, stating, this problem may only be rectified by the legislature.
That's a powerful nudge. It highlights that tension, doesn't it, between the public's right to know via broad records laws and the commercial realities of privatization, where competition is inherent.
It really does. The court applies the existing framework, but Judge Johnson points out that framework might not perfectly account for all the nuances of these public-private arrangements. Maybe the broad transparency rule has competitive side effects the legislature didn't foresee.
It's that constant balancing act. Transparency versus potential competitive harm or disincentives for private companies to partner with government.
And Judge Johnson's point is that if that balance needs adjusting, if a specific exemption is warranted for competitive reasons in privatization contexts, it's the legislature's job to create it, carefully and constitutionally.
So, wrapping up this deep dive into Booksmart v. Barnes Noble, it really offers some potent lessons, especially for our listeners familiar with open government law.
Absolutely. We've seen how Florida's Public Records Act stretches to cover private entities when they perform public functions, that contractual disclaimers aren't foolproof shields.
And the definition of public record hinges on its function, its connection to official business, its purpose in memorializing or communicating knowledge, not just its form or location.
Right. And the big one, acting on behalf of a public agency, makes you a custodian subject to disclosure duties. The functional test is paramount.
Judge Johnson's concurrence also adds that important layer, reminding us that while courts interpret the law, legislatures have the ongoing role of refining it, maybe creating specific exemptions if needed to address consequences like competitive fairness and privatization.
It's a crucial dialogue between the branches of government, really, prompted by these kinds of cases.
So the final thought for you, our listeners. Considering this increasing trend of privatization, what are the ongoing responsibilities of legislatures to clearly define the boundaries here, to ensure both transparency and fair competition?
And how should anyone involved, agencies, contractors, the public, balance these often competing interests when structuring or evaluating these public-private partnerships in the future?
Booksmart v. Barnes Noble certainly tells us the courts will look at what's actually happening on the ground, the substance, not just the words in the contract. Something critical to remember.